All right, let me make sure everything copacetic before I go in. Okay, everything is good. So let's get it. Here go the documentation right here. Hamilton County Juvenile Court. Interrogatories. These interrogatories are what you give and you serve to the Child Support Enforcement Agency, but they don't even understand how wicked and false they are and how they go against their own laws all the time. I'm sure they do. There's only certain people that will, how do you say, remind them of their folly and wickedness with that program. So first you put, of course, your name as the injured party, and you put whoever is the, how can we say this? When you go to court, the Child Support Enforcement Agency has their own lawyer. It's not your lawyer because you are their customer. Because you are the Child Support Enforcement Agency's customer, they have a lawyer in there, but they do not represent you. You are only their. That's why they fill out an application for child support, because they're customers. It is a franchise. But let's continue right here. So you put the particular lawyer that goes to court with you right there, the respondent, as well as whoever the plaintiff is. Usually it's the mother. UD collections case. All right. First line. Now I put some things right here. I actually got this from somebody, but I made it my own, of course. You are advised that the following interrogatories are taken verbatim or are paraphrased from the Section 8 of the Child Support Program Manual, Title 45 CFR. I'm not going to go through all that. Federal Personal Responsibility Work Opportunity Reconciliation Act of 1996, Balanced Budget Act, the U.S. Constitution, and Supreme Court rulings, as well as the Black's Law Dictionary. And they're not objectable. Meaning basically the things that I put in these interrogatories is irrefutable. You can also answer, and I added, of course, some things. You can also answer the interrogatories in complete sentences if you deem the explanation of your answer necessary. So I'll give them a chance to explain where they're coming from. Do not. All right, here we go. Now, right here, PRCP 33, this is the law that they have to abide by. And I'll show you that momentarily. Didn't even think to show it to you. Interrogatory, okay. Okay. So it talks about serving interrogatories. Rule 33, Federal Rules of Civil Procedure. All right. And that is the interrogatories. So they're subject to respond because of the federal rules. All right. So when I serve interrogatories to them, they are supposed to respond to all 19 of these. I'm going to show you that. But here goes the rules, the actual rules. No. Dang, really? Did you get this? All right. All right. So, in accordance with those federal rules, they're subject to, so child support has to do this, okay? Basically saying. And when you look up this FRCP 33, you get all these particular rules. I actually put them on my documentation because I don't want them not to remember what these rules say. Because they have to answer all these questions. So I put the rules down, then I start the interrogatory. I'm going to tell you, This is in the file section. You got access to this, but you serve it to them. Hold on. Let's read about the interrogatories. Responding party. Interrogatories must be answered by the party to whom they are directed. That party is public or private corporation, a partnership or association, or government agency, or any officer or agent, and must furnish the information available to the party. The time to respond, as you can see, is 30 days. The responding party must serve its answer and any objections within 30 days after being served the interrogatories. Shorter or longer time may be stipulated to under Rule 29 to be ordered by the court. Answering each interrogatory must, to the extent it is not objected to, be answered separately and fully in writing under oath. Objections. The grounds for objecting to an interrogatory must be stated with specificity. Any grounds not stated and all this particular stuff. The person must have answer must sign them. So, basically, we're serving this to child support. Of course, we're not using Almighty's word here. We're using the statutes of the United States codes. We're actually using Title 4D. We're actually using the Social Security Act. What created child support. We're using those laws because the same laws tell them to do the right thing. Actually, we read them. But let's go through them. So, pursuant to 42 U.S.C. 654. State plan for child and spousal support must provide for the establishment or designation of a single and separate organizational unit. This right there, this answer right here is basically boxing them in the corner because they're saying that they're not a state agency, but they're a single and separate entity. And this is something that you all have to understand too when you're doing the paperwork. They're not a government agency; they're a franchise. They are separate. That's why they can do contracts. They are not a government agency. They're a franchise, a single separate. Let's continue. 42 USC 654 4D Child Support Enforcement Agency performs its duty under the executive branch of government and not part of the judicial branch. So, child support is under the executive branch of the government, not the judicial branch. Why is that important? Because of separation of powers. Anyone who paid attention to social studies knows that's why we have a separation of powers. So that's the whole thing about our government. It's checks and balances. There's no king. There's just no ruler. But when you combine the executive and the judicial branch and the legislative branch, it is considered treason. And what a child support enforcement agency is doing is committing treason by bribing the court. And we can show you those documents too. But when they bribe the court, as treason. All right. Interrogatories. Pursuant to 1 USC 402, these titles of code, which are not enacted as a positive law, are considered prima facie evidence of the enacted law and are presumed to be law prohibited by the due process clause. So right here, basically, is saying that it's prima facie law. It is under what they call the color of law, meaning it's not really law, and it needs to be challenged. And that's why it's prohibited by the due process clause. So child support, Social Security, when it comes to even children's services, was never enacted in the positive law. Them still in children. Why wasn't it in positive law, just like child support wasn't in positive law, and Section 8 is not in positive law. Those are all under the Social Security Acts, which is prima facie law. So this right here is important to get an understanding of what is positive law. Child support or the Social Security Act, which houses it houses what Title 4A. So it's a Section A. Title 4A. No, it's not welfare. No, right, welfare. It's welfare. I'm sorry. That's section. That is Title 4A. Title 4D is child support, and Title 4E is children's services. All under the same Social Security Act, which was never enacted in the positive law. So you ask them to admit or deny Title 42 of the U.S. Code, which houses the Title 4D of the Social Security Act was never enacted into positive law and imposes no obligation upon those who do not volunteer or consent to be subject to it. They can admit or deny it, or they can write up some things for me because I give them an opportunity to write a couple sentences if they don't believe it. I just want them to answer the question. And they're supposed to answer all these questions. Now remember, we got 19 interrogatories. This is interrogatory 4. Pursuant to 42 CFR 2, whatever, cooperative arrangement, the state plan shall provide that the state will enter into written agreements for cooperative arrangements under 45 CFR. Enter means we become partaker, according to the Black's Law. And an agreement signifies a mutual contract on consideration, wherein parties must have a distinct intention to both and without doubt or difference. Okay. So when we talk about written agreements, we just want them to admit that it's supposed to be cooperative arrangements in regards to 45 CFR when we talk about child support. Is it supposed to be a cooperative arrangement or a written agreement? As it states it's supposed to be. But no, it's not a written agreement. They just put it on you real quick. Let's continue. Interrogatory 5, pursuant to 24 CFR. Requirements for cooperative agreements contain a clear description of the specific duties, functions, and responsibilities of each party. This right here is supposed to be cooperative agreements according to this statute, but they don't have this, of course. So specific duties, functions, responsibilities of each party, the appropriate court and law enforcement officials. Specify that the parties will comply with the Title IV of the Act. Specify the financial arrangements and procedures for billing the Title IV agency for relevant federal and state reimbursement, and specify the dates in which the contract begins and ends. None of this was specified. There was no cooperative arrangement. They just start stealing. They just did an IWO and start stealing. They're supposed to be this. So we asked them, right, is it supposed to be, just so they can see if they're going to lie or not say anything at all. The stigma attached to injured party. Okay, it's a lot of good stuff in here. But I had one more thing I wanted to show y'all. Damn. It was disrespectful. And I feel like I gotta show y'all. I want y'all to beware if y'all even listening now right now. But yeah, if y'all not listening, y'all might not be aware. But it's another group. I'm gonna show it to y'all. Now I think they like mine. I think this group is like mine. But let me show you something I saw that was real shiesty in the group. Look at me. All right. Real child support help. Right? Termination, right? I seen this group, right? Now go to the file section. Right? I just put this one in there, case law for fathers. But what he put in there? Affidavit. No, what was that thing? It was disrespectful though. Oh, okay, see more. I was wondering. Notice of demand for PRC. Now that's what I want to show y'all in this file section. Let me see if I got it. See what? Man, this is stupid. I'm just gonna download it twice. What it hurt? Instead of trying to look for it. All right. All right, right here. Let me see. Make sure y'all can see this shit, man. Man, I can't even see this shit. Let me make sure. All right, right here. The dude I just showed you. Man. The dude, what's the name I just showed you, man? Let me just. Now, he got a notice for demand for personal responsibility contract. I knew it took a long time. I apologize, family. But right here, this dude put this document in his thing. So I said I was gonna check it out. Chill out, Ez. Chill out, boy. It said the Fifth Amendment. Now this right here is disrespectful for him to give this to anybody. And when y'all read through it, it's so messed up. It's so retarded sounding. There's some good stuff in it, but you got to erase like a good fourth of it because it says disrespectful things that makes you look like an idiot. If somebody was just to put their name on this and hand this in, man, it would be, you know what I'm saying? It would be a very bad thing. So this is what I want to say. I want to big up the brothers group, and I want you all to join it. But I hope he's really here to help people because that type of documentation right here. Let's say, for instance, I'm gonna read this anyway. The Fifth Amendment and the Article 1, Section 3 of the Constitution for the state requires that, and then you put your name there, shall not be deprived of life, liberty, or property unless by due process of law. The requirement of the Fifth Amendment, as well as the second, is also present under that CFR, which clearly requires that the due process rights of the parties involved must be protected. And 42 USC also requires that the state must afford due process safeguards. I hope this ain't the one that I cleaned up. Make sure. Oh no, this ain't the one. It is. So that sounds pretty cool so far, even though you got to check and see if all these different ones are right. Pursuant to the Federal Office of Child Support Enforcement Glossary of Common Child Support Terms, due process is a principle of fairness in legal proceedings so that a person has a right to know what action is being taken and an opportunity to be heard. Therefore, pursuant to the supreme law of the land, it's hereby ordered that you will provide the following. In accordance with 42 USC 603, in the case of a non-custodial parent who becomes enrolled in the project on or after the date of the enactment of this clause, the non-custodial parent is in compliance with the terms of an oral or written responsibility contract into and among the non-custodial parent and the entity. Furthermore, Section 42-466 describes procedures to ensure that the non-custodial parent owed the past due support he will work or have a plan for payment. So right here, this right here is disrespectful right here to say this. This line right here. This right here describes procedures to ensure that the non-custodial parent owed the past due support he will work or have a plan to payment. No, we're not talking about owing it. This right here is really fucked up, but it gets worse. This whole thing gets worse. I'm not tripping. The first thing he said, the plan for payment is hereby demanded. Right now, you're demanding you demand to come up with a plan for you to pay. What kind of fucking document is this, bro? The non-custodial parents hereby demanded. That's cool because you ain't your straw man. All information pertaining to the enrollment in the project is hereby demanded. That's a good one. All information pertaining to the personal responsibility contract enter into among the non-custodial parent, the entity is hereby demanded. Yeah, well, and that's a good thing too. And I can show you the personal responsibility contract is in what the Social Security Act, where it's the same one that the houses child support tells you that they're supposed to have a personal responsibility contract with the parent, but they barely never do. Sometimes they may get somebody to sign a contract into that bullshit, but no, most of the time it don't. All information pertaining to the terms of the personal responsibility contract entered into among the non-custodial parents hereby demanded. So that's some good stuff. Why you messing with me, ass? And unless the entity just demonstrate that to the secretary, now this is really messed up. Look at this paragraph right here. And unless the entity demonstrates to the secretary that the entity is not capable of coordinating with such agency, the agency responsible for administrating the state plan under the Part D, which was developed taking into account the employment and child support status. See, this right here is a run-on of confusion. It's not saying nothing. This whole paragraph ain't saying nothing. Which this is garbage. That's why I'm saying you gotta watch out for whoever y'all, if you're listening to whoever. So you got that documentation over there. This document is garbage. This right here is garbage too. Into an account of employment and child support status of non-custodial people which is enter into and not later than 30, or at the option of entire not later than 90 days after the non-custodial parent was enrolled in the project, which at the minimum includes the following. What? That was complete foolishness. It needs to be totally deleted from this whole thing. The full description of the project is hereby demanded. The full description of the program is hereby demanded. That's them cool. Commitment by the non-custodial parent to cooperate at the earliest opportunity, and the establishment of paternities of the minor child through voluntary acknowledgement or other procedures, and the establishment of child support is order is hereby demanded. This right here is telling you to actually do to cooperate and to do it at the earliest. And this is right here is retarded. This right here needs to be erased too. Oh, not gonna say to cooperate at the earliest opportunity. It tells you to cooperate that you need to cooperate. Come on, man, get out of here. A commitment by a non-custodial to cooperate in the payment of child support for the middle child. Why does this thing say middle child? See, that right there is disrespectful to even put somebody to put that in your documentation. Why would you give somebody documentation that would say this type of stuff? This is not even okay, let's read it. And the commitment by the non-custodial parent to cooperate in payment of child support for the middle child, which may include a modification of existing support order, take into account the ability of the non-custodial parent to pay such support and to participate such a parent in the project. So it's a bunch of what's the name? Let's keep it moving though. By non-custodial parent to participate in employment or related activities that would enable the non-custodial parent to make regular child support payments. What? They keep repeating it, but now they're saying in order to make regular child support payments. Like, come on, why would you even put that in? You're not making payments. We're not doing that. Why would we even put that in documentation? Unless they're gonna steal it. Right here said, what does it say? A description of the service to be provided under this paragraph, and a commitment by the non-custodial parent to participate in such services. They are designed to assist a non-custodial parent obtain and retain employment, increases earnings, and enhance the financial. Why would you do that? See, why, Ezra, stop playing with me? Okay, but right here we're seeing. So right here it just says a bunch of garbage. And right here, this is what they have in their file section. And if you don't read the file, just put your name on it and send it to them. It's gonna be real bad for you. There's a lot to add to this too, and I'm gonna actually give you guys a copy of mine when I'm done with it. Okay, but that's all I want to say.